In this video, I'm going to talk to you about why the cops don't have to read you your Miranda rights. Hi, I'm Muthu Veerappan. I'm a criminal defense and civil litigation attorney here in Michigan. I help people fight for their freedom and protect their future. A question I hear all the time is, "Hey Muthu, the cops didn't read me my Miranda rights. That means that the case is dismissed, right?" Well, that's not exactly how it works. Miranda and the case law that flows from it doesn't talk about automatic dismissal. Don't lose hope. Miranda is a very good decision and it does protect your constitutional rights. It's not as good as you think it is, and it's not as powerful as most people think because most people watch TV shows like Law & Order and dramatize the Miranda warning when the police catch the bad guy. Before we talk about the police and their responsibilities, we need to take a step back. So, where does the Miranda case come from? The major issue in Miranda v. Arizona is the protection of the Fifth Amendment privilege against self-incrimination. In 1966, the U.S. Supreme Court decided that there had to be significant safeguards in place to protect your privilege against self-incrimination, which is contained in the Fifth Amendment to the United States Constitution. The Fifth Amendment states in relevant part that no person shall be compelled in any criminal case to be a witness against himself. Well, what does this mean? That means that the police or the government can't force you to testify against yourself. Basically, if you did something wrong, you can't be forced to admit it. In Miranda, the court looked at this and reviewed certain police practices in Arizona. They determined that your privilege against self-incrimination had to be protected. Let's go back to the beginning. In 1963, a man by the name of Ernesto Miranda was charged with kidnapping and rape in Phoenix, Arizona. He was arrested, taken into custody, and transported to what the court later called a special interrogation room. He was in that room for approximately 2 hours with 2 officers. When the officers came out, they had a signed confession. That confession was then used at his trial, and he was convicted. Afterwards, he was sentenced to 20 to 30 years in prison. After that, he appealed the conviction to the Arizona Supreme Court. That court affirmed the conviction based on some convoluted reasoning. Miranda's lawyer argued that his client wasn't given a lawyer while he was detained. The Arizona Supreme Court then came back and said that there was no violation of his constitutional rights because he never asked for a lawyer. The issue was whether Miranda was told he had a right to a lawyer in the first place. From there, the case went up to the United States Supreme Court, along with 4 other cases with similar facts, because we all know that the police had a lot of special interrogation rooms in the 1960s. The court considered how to protect the privilege against self-incrimination. Specifically, they asked what safeguards are required. The court analyzed how a person in a room with officers acts. The entire situation is overwhelming, you're not thinking straight, you're scared, and often things are happening at a very rapid pace. Officers know how to pressure you, ask leading questions, and poke you to get the admissions they want. The court said that there needs to be some protection or safeguards. Eventually, the court overturns Miranda's conviction. The court held that the prosecution cannot use statements stemming out of a custodial interrogation of the defendant unless the prosecution demonstrates that they use procedural safeguards effective to secure the privilege against self-incrimination. Basically, the court said that if the police are going to lock people up in rooms and question them, you have to show the court that the person's rights were protected and that you had safeguards that allow the person to understand, know, and exercise his privilege against self-incrimination. The court indicated that whatever process the police have, at the very least, the person must be warned of the following. First, he has a right to remain silent. Second, anything he says can be used as evidence against him. Third, he has a right to consult with a lawyer before questioning, and that lawyer can be present during questioning. Fourth, that attorney can be retained or appointed if the defendant cannot afford an attorney. The court did not require specific language, but they did require the information is properly conveyed to a defendant. Nowadays, cops just read it from a card. The court found that Miranda was never told he had a right to an attorney, that attorney could be present during the interrogation, and that there was no evidence that any safeguards were in place to protect his privilege against self-incrimination. In a nutshell, that's what the Miranda case is about. The court said that you have to be given these warnings before custodial interrogation begins, but only for the purposes of allowing the use of your statements at your trial. It only states that in certain circumstances, custodial interrogation, that the prosecution has to show you that warnings were given or other safeguards were in place. When are the Miranda warnings required? Basically, it is required when a custodial interrogation occurs. Well, what does that mean? This is questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. The two elements here are the custody element and the interrogation element. We're going to start with the interrogation element because it's a bit easier. It is questioning, but it's also much more than that. The U.S. Supreme Court in Rhode Island v. Innis held that interrogation or its functional equivalent would trigger the Miranda warning requirements so long as it is custodial. The court defined the functional equivalent by explaining that interrogation is not just questions. It's any words or actions by the police or government that are reasonably likely to elicit an incriminating response from the suspect. An example of this is a case where the suspect invokes his Fifth Amendment right. During transportation, one of the officers says that any cooperation will be brought to the attention of the U.S. Attorney. In that case, the court found that this was the functional equivalent of an interrogation. Now let's talk about the other element, custody. If you're not free to leave because the cops are not letting you leave, then you're in custody. Most people think this way, and often they're correct, but there might be some exceptions. The courts have told us that there are certain factors that have to be identified and reviewed to determine if you're in actual custody. The location of the interrogation, if the investigation was focused on you, any objective indicia of arrest, the length of the interrogation, and finally, the age of the suspect. A good example is a traffic stop. Maybe it is custody and maybe it's not. It all depends on the facts of the case. I'm sure the officer will say that no, he wasn't in custody, so I don't have to read him his rights. There has to be some kind of show of authority, some indicia of arrest. You have to show that the cops are limiting your freedom of action in a significant manner. In the example of the traffic stop, the government will probably argue that the stop wasn't significant. It was just incident to the ticket, and the officer was going to let the suspect go when he confessed to the crime. A good attorney will look at all the circumstances. Now, if an officer puts cuffs on you, that's pretty much a gimme. It will definitely count as custody. I've had clients who talk when the cops come to their home. That's likely not going to count as custody. So, to recap, the most important point of this video, does the officer have to read you your rights when you're in custody? If they want to use your statements at trial, they do. If they don't, then they don't have to. I've had cases where the police never ask any questions. If you're not in custody, the police don't have to read you your rights. If you're not being interrogated, then the police don't have to read you your rights. For example, if you start talking when no one is asking you any questions, all of those statements are considered voluntary. It just depends on the facts and the situations of the specific case to determine whether they do or do not have to read you your rights. So, pro tip, ask, am I free to leave? If they say no, then shut up. Literally, stop talking. That's the difference between getting additional charges, potentially going to jail, and going home. The smartest clients I have are those who do not speak. Ask for a lawyer. Assume that anything you say will be used against you. There are some exceptions to the Miranda warnings. These exceptions include the routine booking questions. These questions can't include elements of the offense you have been charged with. If they do, your attorney can make a motion in court to exclude the statements. Another exception is the public safety exception. If the police have exigent circumstances, like a bomb or active shooter, the police can ask you questions without reading you your rights. However, the police can't go beyond the public safety need. So this is why the police don't have to read you your Miranda rights. If they don't want to ask you questions, use your statements, or if you're not in custody, they don't have to Mirandize you. If the police have to read you your rights and they didn't do it and got some statements, then your attorney can move to preclude those statements from trial. The Miranda warnings are an absolute prerequisite to a custodial interrogation. The only reparation you would get is the preclusion of the statements at trial. The case won't be dismissed. Importantly, the police or government don't have to tell you that they plan to use your statements. For all these reasons, you need to speak with a professional before you make any decisions that could make your case more difficult to defend. We're ready to help you. We're open 24/7, and I'll give you a free consultation. You'll sit with me and we'll review your case and see what defenses you have available.
This video is not legal advice and should not be relied on for legal advice. Be sure to consult with an experienced attorney whenever you have legal issues.